Mohammad Khan, who's a spokesperson of the Congress party, is joining us on the broadcast. Mr. Kapil Sankla, who's a lawyer, is also with us on the show. Kailash Vasudev, who's a senior advocate at the Supreme Court, is also joining us on the broadcast. Kapil ji, I'll come to you first. What are your thoughts on these overarching changes that have been proposed by the union government?
I think it's a historical day today for any lawyer, any person who's in any form associated with the criminal law system. There are three major changes that have been done. They've been done under to the IPC, the Indian Penal Code, the CRPC, which takes care of the procedure on how investigations would take place and how the courts will proceed, and the Indian Evidence Act, where how the evidences would be looked into by the court and collected by the investigating officer is looked into. So not just sedition, but you see there is a substantial overhaul in the entire judicial process as far as criminal law is concerned. You now permit service of summons through internet and WhatsApp, etc. You now permit service through WhatsApp and internet, etc. You allow an accused to be present online rather than physical appearance mandated in every occasion. You also permit the prosecution to go ahead with the trial even if the accused is not there. Because what would happen is that the accused, especially when it comes to heinous offences, etc., or where criminals, peshevar criminals, what would happen is that they would vanish and the entire trial would come to a standstill. Or when there are multiple parties, one of the accused would vanish, making sure that the trial is stuck for next 3, 4, 5 years. So those are substantial changes that I see. As far as the Evidence Act is concerned also, it's very important to note that recording is actually now allowed. And also recording of the procedure of the court is also now allowed, because this is now virtual. So therefore now there is a lot of responsibility on every stakeholder in any criminal prosecution system. So the stakeholders, who are the stakeholders? We as lawyers are stakeholders. We are responsible because our conduct is getting recorded.
No, on a lighter note, and Twitter is full of memes like that. I'll bring in Mr. Kailash Vasudev also on that. I mean, we'd all have to mug up the Indian Penal Code yet again. Many people are arguing that good, you're making these substantial changes, but why do you want to overhaul everything? The entire jurisprudence, Supreme Court judgments, how the police and the courts and the trial courts and the magistrates and a local policeman on the street knows law, is because everybody knows what 302 is about, what 420 is about. If you overhaul everything, the common layman understanding of what law really is will go for a complete toss. Already the legal awareness in this country is already very, very low. Mr. Sangla, Kapil.
Right. So the short answer is this. This was coming. It's been delayed for decades. Our laws are so old that you will be surprised to know that the Britishers who gave us that law actually gave up that law in Britain. There is no Sedition Act there. There are no sedition laws there. Now, you said something very importantly, that it is the vagueness of the law that creates discontent, disharmony and misuse.
Yes.
And it is high time that we bring in better laws, more specific laws, more pointed laws.
Yes.
Because you would otherwise let the police wala do whatever he wants to do. So that was a really good beginning. I like that. And that is why these laws need to be overhauled today.
All right. Mr. Kailash Vasudev, before I take in a word from Mr. Sulaiman Mohammed as well, who's patiently listening to this discussion, much has been talked about the law of sedition, 124A. It must go away from the statute books. I think the Supreme Court said it. The law is in abeyance. It had to happen. But there is a different chapter, Chapter 7, if I'm correct, that has been proposed that should replace, the offence of sedition. And this chapter talks about the offences against the state, waging or attempting wage a war against the country, conspiracy to commit offences punishable by 145, concealing with intent to facilitate or design a wage war. Do you think that this is the right approach that has been taken by the union government, doing away with that vague section and further exhaustively trying to codify this?
Good evening.
Good evening.
In the first instance, the sedition provisions should have been removed long back. Because we had parallel proceedings which are available, the Defence of India Act, the Defence of India rules. All these were available for those who were acting against the interest of the state. You are now amending it and slipping it in a different direction. You are bringing in sedition under different heads in a different group in a different chapter totally.
Okay.
But where do you say that these provisions are going to be honestly followed without causing any embarrassment to anybody? Laws always exist. Laws will always exist, and laws will always change. That's the grundnorm of society.
Yes, sir.
It is how do you implement them? Do you use the same stick? Do you use the same provisions for purposes of intimidating somebody? See, I say this because in the past 20 years, we have been seeking to overhaul the law. We have made huge changes in the law. You had as many as 30 constitutional amendments. You have brought in all sorts of changes, right from Aadhaar down to sedition, down to individual rights, down to reservation. You know, we are a melting pot of democracy. But in this melting pot of democracy, what we have to ensure is that the citizen is not intimidated by governmental action. If you are going to remove sedition and bring in other provisions, then please make sure that policing is also tested. One very salient fact which is now taking place is that the number of convictions are dropping by the day.
Yes.
So what happens is Mr. X has been arrested for a charge in 2020. His trial finishes in 2035. That was going up to the Supreme Court. So 15 years this man has been in custody. His best years of his life are destroyed.
No, you're right. You're right. The process becomes the punishment, and
now,
this was finish your point.
It is here that we have a suggestion which we see from courts in our daily practice.
Yeah.
If there is an acquittal based on a charge, the investigating officer who filed that case, the investigating process which took place must be tested. May not be by the court, but by the police itself. Because at the end of the day, the person who has been arrested, tried and acquitted, you've destroyed him. You may not have destroyed him.
No, that's